Good afternoon again, everyone. Welcome to our next Back to Basics webinar. This afternoon, where I'm delighted to have Simon and Sarah talk about IP. Just a few bits of housekeeping to start with. All of your cameras and microphones are off. We'll be recording the session and circulating it at the end along with the slides. Please do send questions as we go through. We've got time for Q&A at the end, and we won't attribute any questions, so please do ask away. I think a lot of you have received this invite through colleagues, so please do let us know if you'd like to be added to our newsletter directly, so you can get the invites directly. I think that's it on housekeeping. So let's get started. I am very happy to be joined by Simon and Sarah today. Simon's a partner in our IP team, and Sarah is a trademark director, as of Saturday, a partner in our IP team. So it's great that they're joining us today. The Back to Basics is so the headline, they're going to talk about the different types of intellectual property, and they'll run through those between them, and then they're going to talk about recent infringement cases. I think they'll talk for about 35 minutes, 40 minutes, so there'll be plenty of time for the Q&A at the end. So with that, I'll hand over to Sarah.
Next slide. So as Lucy said, we're going to be giving you an introduction to IP. The talk we're going to give is going to be an overview in relation to the different types of intellectual property rights there are. We're going to talk about trademarks, we're going to talk about passing off and designs. We're also going to go into copyright and patents. Everybody should know what the differences between those types of rights are, but in relation to trademarks, that protects the brand in different forms. It can be various types of marks. Passing off, that protects goodwill, and it prevents misrepresentation of the rights. Designs are usually 2D or 3D objects, and the protection lasts for, depending whether it's unregistered or registered, up to 25 years. Copyright, that can protect the artwork, photographs, music and software, and can last 70 years. And patents, that's inventions and can last 20 years. So next slide, please. So as I mentioned briefly before, trademarks identify and differentiate the goods and services of one undertaken from another. It can be any sign which is capable of being represented graphically and distinguishes those goods or services. There's a variety of forms of trademarks that you can have. You can have word marks, logos, sounds, smells, which is quite an unusual one and very rarely is applied to register. Colours, shapes, slogans, letters. So there's some examples of some different types of trademarks that you can have. The first one, as you can see, that's clearly a word mark. It's just a word, and it's just usually in plain block capitals. A stylized word is usually when it's stylized in some form, and it could be in colours. And again, I've shown that in a stylized form. A logo is usually doesn't include the words, but it's usually some sort of figurative element. If you see that one there, it's for the L and the M logo. And slogans are registered. In the UK and the EU, it's very difficult to register slogans. They have to be quite unusual, and we often get quite a lot of pushback in relation to slogans, but it is possible to register slogans. Next slide, Jess. This is a registration of a colour mark. It consists of the colour orange, and it's shown as depicted there, and it's registered for transportation services, and it was originally refused on the basis that it was inherently non-distinctive, but sufficient evidence was filed to show that by the date of the application, the mark had acquired a distinctive character, and given the use made of it, it was registered actually in the UK. Next slide, please, Jess. So this is a movement mark, which is owned by Scandlines Denmark. Movement marks are relatively new, and again, can be quite difficult to register, purely because it's quite hard to show that the relevant public see the mark as a trademark, and that it differentiates the goods and services of one undertaken for another. So this is quite an interesting one, but it is for a Danish travel company. So next slide, please. So that was that's a sound mark that's been registered for British Airways. As you can appreciate, again, it's quite difficult to protect sound marks as trademarks, mainly because it's quite hard to, well, originally it was quite hard to put on the register how the mark would be perceived, but now with technology it can be done as a sound clip like this one is, or previously it was done by musical notation. Next one. This is, and that's just another sound one to show you that it is possible to register sound marks. So as I previously said, trademarks are registered in goods and services. There's 45 classes that you can register trademarks in, and everything in basically that you can get will fall within one of these classes. Here we've just given an indication of the types of things that are included in each class. In relation to the travel industry, the main class of interest are the ones that I've highlighted there. So class 39 in relation to transport services, so that includes by any type of transport, by air, by train, or anything like that. Class 43 is the hospitality services, so it's more like the hotel services. Also covers the provision of food and drink. Other ones that might be of interest to travel industries are things like class 41, which is provision of entertainment and sporting events. Class 36, which is for travel insurance. Class 35 for things like business administration. And also class 9, which covers goods such as computer software, so it would cover you for the apps, and on the flip side of that, class 42 would cover you for the software as a service. So everything needs to, when you file trademarks, everything has to fit into one of these classes, and that's how you register the trademarks. But trademarks can coexist in different classes if the goods and services do not conflict, or if the parties agree to coexist. So if you go on to the next slide, please, Jess. Here's an example of where identical trademarks that are registered, but they cover very different goods and services. So everybody's well aware of like the Polo Ralph Lauren, which is registered for clothing, class 25, Polo Mints, which are registered for class 30, which are confectionery sweets, and the Polo car, which is registered in class 12. Obviously, there can be issues where companies which have an extensive reputation can prevent third parties from registering an identical mark on any goods and services, and there is a particular right that you can apply for that type of action. For example, if I brought out a range of I don't know, tea bags. No, tea bags probably not a good example. Toilet brushes, and I called them Coca-Cola. Coca-Cola are not going to be very happy about that, and because they have such a great reputation, they will be able to stop you from doing that. So next slide. So how do you register trademarks? I'm going to talk about registering in the UK and the EU on this talk. So in the UK, you filed trademarks at the UK IPO, and in the EU, you'll file them at the EU IPO. once an application is filed, and like I say, you include the goods and services that you want to protect the mark for, you include a copy of the mark, whether it be a word mark or logo, and you file them at the relevant trademark registries. The examiners then review the application to see whether all the goods and services have been sufficiently classified. So, for example, if you put transportation services and you put it in class 36, the examiners would come back and say, well, actually, that should be in class 39. Please, can you move it? They will also, both the registries would conduct a search of the register to see if there were any earlier similar marks on the register already. They will notify you about these marks, but they would not refuse your trademark application on the basis of those marks. What they would do is, if you requested that your application proceeds to publication, they would then notify the earlier rights holders that you have filed a trademark. So, for example, if you filed for the mark Easy Group or something like that, and the Easy Group marks were cited in your examination report, the examiner would notify Easy Group that you had filed the trademarks. Once the mark has been accepted and it goes through to publication, in the EU, you have 3 months to oppose the trademark, and in the UK, you have 2 months to oppose. But you can get an extension of time to oppose the trademark in the UK, but that's just 1 month, that you get an extra 1 month. Some people I've heard over the years have heard that an extension of time has been filed by another party, and they believe that then they can file their notice of opposition because the company has filed an extension to oppose. But you can only oppose a trademark in the UK within the last 1 month if it is you that have applied to get the extension of time. And the UK IPO are very, very hot on that. And even if you've filed it in the name of the wrong company, the extension, and it's got a slight different name or anything like that, most circumstances, they will refuse the notice of opposition. So it's always important to get that form correct. If there's no oppositions, then the trademark is registered, and it will be registered for 10 years, and it can be renewed indefinitely. Just because you've got the trademark, it doesn't mean that it's safe and nobody can do anything about it after it's registered. If somebody forgot to oppose, for example, they can file an invalidity action on the basis of their earlier use or earlier registrations. Or if they think you're not using the trademark, after 5 years of registration, they can apply to cancel your mark on the basis of non-use. So your marks will become vulnerable to a non-use action after 5 years of registration. So next slide, please. So how do you monitor the register to see whether any other parties have filed marks that are similar to your brands? You can commence a watching service if you haven't got them already. So a watching service will search the relevant registers. You can restrict them back to just the UK or the EU, or you can do worldwide watching services. You can only watch specific classes, or you can only watch marks that are of particular interest to you. We get reports on a daily basis, and we report them to the clients on a weekly basis, where we notify of marks that have been filed that are similar to our clients' marks. Then people can decide whether to oppose the trademarks or send a cease and desist letter, or both. But what does it really mean to oppose? So if you do want to oppose a trademark, you have to have earlier rights to oppose that trademark. So if somebody filed a trademark application that you think is similar to your brand, you can file a notice of opposition, which sets out the grounds on which you are relying on to oppose the application. Normally that would be earlier registered rights, like I've said. So if you've got an earlier trademark, you can rely on passing off. And as I mentioned before, you would show that you've got a goodwill, that you've got that there's been a misrepresentation and that there's damage. And there's various other grounds that you can oppose on. The reputation ground, which I mentioned before, that it might not be the same goods and services, but you think that your brand has such a reputation that you can prevent somebody else from registering. Or there's various other things like bad faith. So if there was a business relationship between you and the party that's applied for the trademark, if you can show that they were aware of your intention to file the trademark and you didn't have earlier trademark rights, you can oppose if you can show that there was a business relationship. When you oppose an application, the opposition gets sent to the other side, and they have in the UK at least, they have to file a defence to the opposition. If they don't file a defence to the opposition, then their application would still be refused. In the EU, it's slightly different. So if you oppose in the EU, the other side do not have to put a defence in. So you could be 2 years down the line on a case in the EU, and the other side have not even responded to any correspondence, and they potentially could still win. So in relation to succeed in the opposition, if you have got earlier rights, you have to show that the marks are similar, the goods and services are similar, and that there is a likelihood of confusion. And if you can show all that, then you should succeed in an opposition. I think I've gone through that on the, sorry, I went through that on the previous slide. So that just sets out exactly what I was saying about in relation to, I should say that I didn't really mention that. If it is identical goods and services and an identical trademark, you do not have to prove a likelihood of confusion. So that's quite good. And I have already mentioned about the dissimilar goods and services that you can if you have got the reputation. So this is a case in relation to the trademark Seated. The applicant was Seated Technologies, and they were opposed by Seated Inc., who had a trademark that had an unregistered trademark, sorry, not a registered trademark that they'd used since April 2017. It was shown that, yes, the use was prior to the date of application of 9th of October 2019. So they were definitely the prior user, but the opponent didn't really have sufficient use. So their evidence was held to be insufficiently solid. So they their action failed on that. They also tried to bring a claim for bad faith. And like I said previously, they had to show that there was a business relationship, which they weren't able to do so in this situation. Next slide, please. This is a trademark opposition. It was Pegasus Airlines versus PegasFly.com. This was in the UK, and they relied on earlier trademarks for the flypgs.com Pegasus Airlines marks. And it was in relation to services in class 39, which was transport services. In this case, Pegasus Airlines were successful because the hearing officer said that the average consumer is likely to be confused because they might assume that Pegas was a foreign language equivalent of Pegasus. So they were successful in that case. Next slide. So in relation to designs, there are a number of different designs rights. There are UK unregistered designs, UK registered, EU unregistered, and EU registered. For the purposes of these slides, Simon might talk a little bit about it later on because he's got some slides on infringement at that. But in relation to the registered rights, they last once you file the trademark, the designs, they last for 5 years. Unlike trademarks where you renew every 10 years, you have to renew them every 5 years, and they're not an indefinite right. You only get 25 years of protection. So in relation to the registered rights, it can cover things like the whole product, or it can be parts of the product. It can be shapes, it can be colors, it can be logos, it could be anything that's 3D, 2D. And in relation to infringement, you have to show that the informed user would consider that there's the same overall impression. So next slide. So in relation to travel designs, here's an example of some designs that have been registered. These are registered, I think, in either the UK or the EU IPO. So as you can see, there are a number of different things that you can register as designs. There's a luggage tag, logos, pillows. Next slide. And then here's some really interesting ones. There's user interfaces, which we have done some of those recently. It's becoming a lot more common, as you can appreciate. There's a 3D scale model of a hotel, which was quite interesting as well. So you can register most things as designs. So next slide.
Thank you, Sarah. I think it's my turn now. So I'm just going to run through some other IP rights. Sarah's talked about trademarks and designs, and then I'm going to talk about some infringement cases, which hopefully will interest you. I'm sorry that I'm slightly silhouetted, but I have the sun behind me. So the first topic, patents. As you can see from here, the patents that you have to register to get protection, and they normally they have, there's as you can see from the patent on the screen, they're normally for a particular invention, and in this case there's an example on the screen of a tandem wing aircraft that Boeing had filed. I don't think this aircraft ever went into production, but nevertheless they patented it anyway. Unlike trademarks, you don't have to use the patent for it to be valid. But the most important thing about patents are that they must be novel inventions. And this can extend, in fact, to things like software if they have a technical effect. So that's patents. I mean, it's a much broader subject than that, but just as a taster, that's the patents. So if we can move on to copyright. Copyright is you don't have to register for protection. It automatically arises provided the work is original and is in a tangible form, and it generally lasts for 70 years plus life, so it lasts a long time. It most often arises in things like photographs, text on websites, that sort of thing. It covers the entire world as well through an international treaty. So even if the copyright owner lives in America or Japan or another country, they can still enforce their copyright in the UK. So that's copyright. If we go on to the next slide, it often arises in employment situations, and I think the most important thing to take home from here is that if an employee creates a copyright work, so if one of your employees writes something, takes a photograph relating to the work, or does a diagram or that sort of thing, those works are automatically owned by the employer. So that's a good thing, because it means you don't have to have an agreement or an assignment of the copyright from the employee to the employer, or the employer to own the copyright. However, if you have a freelancer or a contractor, or if, for example, you employ a web design agency to design your website, the first owner of that copyright will be the person or the company who's created it. So if you've got a freelancer who's creating something for you, a bespoke design or something like that, you should make sure you have a contract with that person or that company to make sure that the copyright in what they produce is transferred to you, and you own that. Next slide, please. The question of infringement is a big copyright infringement is a big subject, and we'll come on to that in a little bit more detail later on. But generally speaking, the test for infringement is whether there's been copying without permission, and also how much has been taken of the copyright work. It's a qualitative and a quantitative test. A good example of that, of the sort of how the test works, is imagine a TV broadcast of a football match. So if 3 goals have been scored, then if you just copy the broadcast, if you just copy the footage of those 3 goals being scored, that will probably amount to a substantial part of the work being copied, because it's qualitatively those are probably the highlights of the match. Conversely, if you copied 70 minutes of the match out of a 90-minute match, that probably on a quantitative basis would amount to a substantial part. So next slide, please. We often get asked this question, and it's quite a common thing to happen. In fact, when you're creating your website, or you're uploading photos, and an enterprising person in the marketing department or your marketing agency produces some beautiful photos. You don't know where they've come from. If those photos have been taken from another website or a photo library somewhere, chances are that somebody will own the copyright in that, and you can't use those photos unless you have permission. And there are in fact copyright agencies who scour the internet looking for infringements of this type, and sometimes we've had to help people out of situations where they have used photos in this way and have had to pay a royalty for the use of those photos. So normally you should, just because the photo's on the internet doesn't mean it's free to use. I think is the take-home message for that. Next slide, please. Let's have a look at some recent infringement cases. This is a right which we haven't actually mentioned previously. It's confidential information. And this case, some of you may be aware of it, and it's it's not uncommon, this sort of situation. Some ex-Trailfinders employees moved over to a rival, as you can see from the slide, travel counsellors, and they took some client lists with them, some lists of customers, and Trailfinders weren't very happy with that, because obviously in a travel business, your customers are it's quite important that your customer list is quite important. So they sued travel counsellors for breach of confidence, because they had taken the information that these employees had taken from Trailfinders, and they were using it for their own benefit. And they won the case because it was held by the court that the Trailfinders, their client list or their customer list was confidential to Trailfinders, and therefore the employees couldn't just take that and when they went to another employer and then reproduce that client list for travel counsellors' benefit. So unfortunately, travel counsellors lost that case. Next slide, please. I think Sarah sort of touched on this scenario a little bit earlier on. And this is an interesting case, not because of the infringement aspect of it, but because of the requirement to use a trademark if you register it. So remember, I said if for a patent, you didn't need to use it to have a valid patent. With a trademark, you have to use it within 5 years of registration. Now, this particular case involved the trademark Easy Office, which had been registered by Easy Group, and they tried to stop another company using the name Easy Office, but unfortunately, Easy Group had registered the trademark over 5 years before it took the legal action against Nuclei Limited for its use of Easy Office, and in which case they weren't able to win the case because Nuclei counterclaimed that their trademark was invalid for non-use. So unfortunately, Easy Group lost that particular case because of that. So the moral of that story is use it or lose it. Next slide, please. this is an interesting case involving logos. We put on the screen here passing off, but it's also a trademark case. It applies to trademarks as well. Sarah mentioned about the need for there to be goodwill for if you want to use passing off as a way to stop somebody from using a similar logo or mark. So you have to show you have goodwill in the mark. You have to show there's been a misrepresentation, which normally is done by showing that customers or members of the public are confused. And then if that happens, then normally damage is assumed to have taken place. Now, in this case, it's the familiar Enterprise Rent-A-Car logo, and Europe Car using a moving E logo as well. And in this case, the court held that Enterprise's logo was infringed by the use of Europe Car's moving E logo, and primarily because both were using in the same industry sector. So, for example, if the E logo hadn't been Europe Car using it, let's say it was a pharmacy using the E logo, or a pharmaceutical company, or a business that's in a completely different sector, it's unlikely that Europe Enterprise would have won. But in this case, it was found that because they were effectively competitors, the use of an E logo of a similar form, given Enterprise's well-known E logo, that was found to be an infringement. So next slide, please. This is another example of a passing off claim. So this one is an interesting one, in fact, because it involves also copyright, and the issue is copyright in photographs, as I mentioned earlier. But this is slightly different in that the case involved a license. So what happened here was Linfoots Limited, who were the defendant, they had engaged an agency to take photographs, and the agency retained the copyright in the photographs, but gave a license to Linfoots to use those photographs in its advertising. And then, well, after a while, the agency, the contract with the agency expired, but Linfoots continued using the photographs, and then the agency tried to stop Linfoots from using the photographs, but the court held that they were entitled to still use those photographs, primarily because the license that had been given was it didn't terminate at the end of their relationship. So this case sort of turned on the contract, and I think the moral in this case is to be very careful when you enter into contracts with agencies to make sure that the rights, you're getting what you think you're getting, and also you're getting as much freedom as possible for the use of the copyright images or the photos or whatever it might be that you can. Next slide, please. Sarah mentioned designs, and this is an interesting case involving the Virgin upper class seat, which some of you will be familiar with. If we go on to the next slide, you'll see a better picture. This was quite a big case, actually, and involved not only designs but patents. So the design right case involved unregistered design rights in the seat design, and the patent case, the patent part of it was because Virgin had got a patent as well for how the seat worked. But unfortunately, Virgin lost this case, as some of you may be aware. And on the design right case, they lost because there was no proof of copying, because that is a prerequisite for infringement in unregistered design rights. And unfortunately, in the patent case, there was no infringement because what Premium Aircraft had done was slightly different. So the patent had set out a particular way in which the seat worked, and Premium had designed a seat which worked slightly differently. So it was quite a complicated case, but that's the essential takeaway from that one. But it just shows you that These things, there is quite a lot of intellectual property in aircraft design. Next, please. A hot topic currently is the issue of screen scraping. And this is a combination of copyright, potentially database rights, which hasn't been mentioned yet, which is another IP right, and also possibly trademarks and passing off, and also possibly breach of contract. And finally, there's a competition law angle as well. So as some of you will probably be aware, the issue of screen scraping arises if an OTA extracts data from an airline's website for its customers. And the particular problem here is that Ryanair in particular doesn't like OTAs from doing this, and they've brought legal proceedings in a lot of countries around Europe to try and prevent that. They've been successful in some countries and not successful in others. So it's a bit of a patchwork in terms of how this works, and it also underlines how complicated and complex this area is, in particular in the area of copyright infringement and database rights. There's also a breach of contract angle, which we can come on to because of the website terms of use. And then finally, there's, as I mentioned, there's potential for a defense if you are an OTA by saying that Ryanair is in breach of competition law. So next slide, please. So just looking at it in a bit more detail, the breach of contract part, that arises because obviously Ryanair has its own terms of use when you go onto their website, when you're looking at airline price, the prices of seats on their particular routes, and Ryanair's terms of use don't allow third parties to book seats, but effectively on behalf of other people. And so one of their arguments in the cases that they brought against OTAs is that there's a breach of contract because the terms of use of when you use their website doesn't allow OTAs to take data on airline on the seat price and use it for their customers. So that's if we can go on to the next slide. On the copyright front, again, Ryanair have claimed that their website, the prices of their airline, their seats are effectively, that's copyright material, and therefore that is an infringement if you take that data and put it on another website. Ryanair haven't been very successful in this aspect of things because the courts have generally held that there might be copyright in the way the whole website is laid out, but not in terms of the actual particular data itself. There is an issue with trademarks. So if there's if you use the Ryanair logo, maybe I'm using Ryanair as an example here. If you use the Ryanair logo, then that could be trademark infringement if you use that without their permission. And there's also the potential for passing off. Next slide, please. I think that's over to Sarah.
Thank you, Simon. So another big topic in the IP industry at the moment is IP and the metaverse. Fashion brands are taking advantage of the metaverse and registration of NFTs as trademarks at the moment. It is possible to register them as trademarks. The way you do that is by registering them for the goods and services which would cover those types of goods or services. So there's a lot of protection in relation to Class 9 for the computer software, Class 35, which is the retailing of the digital assets, and also Class 42, which is the software as a service. like I say, it's mainly the fashion industry that are doing it. So Hermes have registered the baby Birkin bag in the metaverse. And when I say register in the metaverse, and I have been asked this question before, there is not a trademark registry in the metaverse. You have to register your trademarks in the UK, the EU, or the US. That's how you protect them. In March 2022, there was the first Metaverse Fashion Week, and brands were exhibiting on the Fashion Week in this metaverse. I think in relation to fashion brands in particular, these rights will be relied on quite a lot going forward. And so it is something that is happening a lot more, the registration, and we should potentially see people taking action in the next, hopefully 6 months, maybe next 2 years. Definitely there's going to be a lot more action in the metaverse. How does this affect the travel industry? Sorry, next slide, yeah. The travel industry is heading in the same direction as the fashion industry. The Marriott Bonvoy released a collection of the travel-inspired NFTs in 2021, and the idea of registering in the metaverse means that, like the Fashion Week, consumers could have their holidays in the metaverse, or see what's happening in various jurisdictions before they go on holiday. So next slide, please, Jess. I don't know about you, but I think I'd rather go to the actual place than do it like that. But I suppose some people find that interesting. So over to Simon. He's going to talk a bit more about IP audits and health checks.
Thank you, Sarah. Yes, I think just final 2 slides you'll be pleased to hear before Q&A. Yeah, we do a lot of IP audits and health checks for clients, and recommend that companies review their IP portfolios regularly to make sure that they are properly protected. Some examples of on the slide of Thomas Cook's ever-changing logos over time. So if you do change your logo, you will have to change your trademark if you've got one. That's one issue. But also health checks are good to make sure that you're properly registering what you have, and also your contracts that you enter into your IP is properly protected, and also you're not giving away IP inadvertently when dealing with third parties, customers and suppliers. And also, you know, if you're innovating at all in terms of designs or inventing new products, again, those should be protected as far as possible. So we're very happy to do an IP audit or an IP health check, and we do recommend that we do those. Next slide, please. I think I've probably outlined already on this slide what we can do in terms of an IP audit or an IP health check. So hopefully that's very clear. And over now to Lucy for the Q&A.
Right, thank you both very much. Yeah, very whistle stop on all things IP, which is great. And we've had a few good questions coming through. So yeah, they cover the whole range of topics that you've talked about. So let's start with this one. So I think it's about copyright and potential copyright infringement. That if a tourist board or hotel website has a photo gallery with a download option, can the images be downloaded and used without written consent? I think that probably happens a lot.
Okay, thank you for that question. I suppose it depends on the term. Well, it depends on the hotel's terms of their use on their website, and if there are any terms when you download the photos. So sometimes that when you download photos, there are terms that say that they can't be used for certain purposes. Generally speaking, if there aren't any obvious terms, the photos would still be copyright protected, and it wouldn't necessarily, just because you can download them doesn't necessarily mean that you can use them for commercial purposes. But it could be that if the hotel are intending those photos to be downloaded to be used by maybe travel operators to help promote the hotel itself, then you could argue potentially that there's an implied license there, that the hotel have given that permission. But it does depend generally on the situation and what I suppose what terms of use the hotel has on its own website.
All right, thank you. I think this next question is along similar lines. It's a slightly longer one, but the travel company works with destination management companies who source hotel supply. Their travel company's contract is with the DMC, and the DMC in turn has the contract with the hotels. Our contract with the DMC has a license, an IP license to use the images that they send to us. But rather than the DMC providing us with the images of hotels, the DMC asks us to get them from the hotel's website directly. As our contract and IP license is with the DMC, are we still covered if the hotel provides us with the images instead?
Again, that depends on the contracts that the DMC would have with the hotel, or whether the hotel has given permission. And just because, if you've got an IP license from the DMC, that doesn't mean that the hotel has given permission. You'd have to make sure that the hotel has given permission to the DMC so that they could therefore pass on that permission to you. So you can't, and if that has happened, then it doesn't matter if you get the photos direct, because if you've been given the permission, the method of delivery is probably not an issue, and where you get them from. But I think generally speaking, again, it goes back to a similar point really, that the hotel will normally own the copyright in those photos, and if they don't, the DMC won't be. DMC is not the copyright owner. They can't necessarily give you permission unless they've been given permission by the hotel themselves to sub-license or to pass on that copyright license to you.
How, because I imagine this happens a lot, how can the travel company best protect itself in that sense, in that scenario?
I suppose what you could do is when you're dealing with the DMC or the third party intermediary, you could make sure that you could ask them to confirm that the hotel has given that permission, and therefore they are allowed to use it. Or when you're getting the photos direct from the hotel, you can reconfirm, maybe not that practical, but you can reconfirm with the hotel that those photos you're able to use them. I mean, it might be that in a lot of situations, if the hotel's keen to advertise its premises, then it might, even if it is technically a copyright infringement to use the photos, if by using the photos you're helping to promote that hotel, I'd have thought commercially the hotel would be less bothered about that. But it obviously depends on the situation. But generally speaking, it's better to try and get that sort of permission if you can, and if you can't, then it's a question of making sure that the DMC has been given that permission.
Thank you. Next question, let's go with if our employees develop some software for us, what's the best way to protect that software? I guess more generally, what's the best way to protect software with IP rights?
Well, with software, the best way, to be honest, the best way to protect it, if the employees, first of all, as employer, you will own that copyright in the software because the employees created it. So that's automatic. In terms of protecting it against third parties, what we normally recommend is that the software developer should put some lines of redundant code in the software so that if somebody then copies it, you will know that it's been copied because it's got redundant. If the copy's got redundant code in it, which is not necessary for the performance of that software, then that would show that there's been some form of copying because there'd be no need to have that there. The other thing to do, which I mentioned earlier, was potentially patent it if you can, if you can show there's some sort of technical effect. So that's another possibility of protection. But generally, the other thing to do with employees as well is to make sure that when they leave, if they leave, that they sign some sort of additional agreement with you, which says that they're not taking anything with them, any confidential information. So going back to the trail finders case, they're not taking any confidential information or copyright material with them, just so that you've got an extra sort of belt and braces contractual right against them if they have done.
Okay, great. Next question might be one for you, Sarah. In the metaverse, what kind of claims do you think could start coming out from trying to protect IP in the metaverse?
I think it's going to be quite difficult to say at the moment, but I think unless parties have applied to register their rights in the metaverse, they're going to find it quite difficult to take action. We have been looking at whether if, for example, a clothing brand, it's something that we looked at before, if a clothing brand has got a registration for clothing, whether they would be able to take action against a party that's using that clothing within the metaverse. And I think Simon and I both decided that that was probably a pretty good case for that, but it's always best to get the protection, and that's exactly why all these companies are actually putting the protection in place, ready for action to be taken at a later date. It's pretty new. No action's been taken as of yet, but things to come.
Mm-hmm. Yeah, watch this space. Okay, last couple of questions. I think we've just got time. Screen scraping, probably for you, Simon. As an OTA, what is, if we were thinking about screen scraping, what are some tips you could give us to make sure we do it in the most legal way possible?
That's a difficult question because it depends on exactly what you're doing and how you're doing it. Well, one way around it could be to use a third-party provider, maybe. So instead of screen scraping, instead of you doing the screen scraping, you contract a third party to do it on your behalf, which means that you would not then be a party. You would not then be screen scraping yourself, and therefore not in breach of the terms of use of the website potentially. That could be one way of doing it. I think it's very difficult because it's very difficult. Depends on how you're doing it and how much material you're taking as well, because that does have an impact on any potential copyright or database right infringement claim. So all of those factors generally have to be looked at on an individual case-by-case basis. So it's difficult. There's no sort of easy solution, and that's why as I said earlier, with Ryanair have been successful in some cases but not others, because it's not a sort of one size fits all solution for this, or there's no silver bullet, for want of a better term. So I think, yeah, I mean it does vary. There's also, I'm mentioning Ryanair. I mean, there's other, it's not just Ryanair, is it? So every airline has different terms of use policies, and those need to be looked at from the contract point of view.
Great, thank you. We'll just take one more then, this last one. And you may have covered it when you did the copyright infringement, but if I pay a third party to design our website, does the fact that I'm paying them not automatically give me the rights in the what in the design?
No, it doesn't. It gives you a license to use it, because you're obviously, that's the bargain you struck with the designer, but the designer will still own the copyright unless you have a document that transfers assigns the copyright to you. So I mean, that doesn't mean you can't use it, but it just means that you can only use it for your particular business, and it may mean that you can't use it for other things. So it's much better, and also it doesn't mean you can, if somebody copies what you're doing, you can't take action against them because you won't own the copyright, because only the copyright owner has that ability to take the action.
Right, thank you. Because I think a lot of people do think that if you pay for it, you get it, but it's good to know that you don't.
No, unfortunately not. If only.
If only, exactly. Great. Well, I think that we'll draw it to a close there. Thank you very much, everybody, for joining and for your questions. It's been great to have you on again. I'll just plug our next webinar, which I think it's the 21st of June, which is another Back to Basics, and it's Back to Basics on the package travel regulations. So a different topic again. Great if you can join us, but we'll send invites out again soon. But I'd just like to thank Simon and Sarah very much for doing today's session. And if you do have any follow-on questions, just give one of us, drop us an email, give us a call. The slides will have our contact details on. So yeah, we look forward to hearing from you. Thanks very much again. Have a nice evening.